1015. This is the Developmental Disabilities Administration Services Eligibility for Recently Relocated Individuals, Ralph's Act. You can bring your panel up, yes, and begin your testimony when you're ready.
What order we're supposed to be in?
No, it's fine. Thank you, Madam Chair, and congratulations again. It's the first time in the new Health Committee. Appreciate that. I'm sure many of you are not sad that you gave us the government operations side of things in GLE. And Madam Vice Chair, good to see you all, colleagues. For the record, Delegate Jared Solomon here to present House Bill 1015, also known as Ralph's Law. I want to just say that this is, I think, the first time that I've ever specifically introduced a bill that came out of just one constituent issue. We often, I think, in our district, as I think many of you do, we work with a lot of our constituent groups and come up with really great ideas. It's blessing and the curse representing really brilliant people is they know exactly what you're doing, but they also come up with some of the best ideas. But this bill in particular, and you're going to hear from Stephanie, who I've known for a long time, even before I was in elected office through shared work at one of the local elementary schools PTA. I don't know that I've ever had a more frustrating constituent case. I don't know, in all honesty, that I've ever been treated or had my office treated in a worse way than we were in handling this case with the Developmental Disability Administration. And I don't do that to cast aspersions on agencies. Those of you who have worked with me know that I'm the most collaborative, willing to bend over backwards to work with folks, but this literally went on for a year and a half. And at its fundamental core, as you'll hear from Stephanie, this was about trying to do what was best for a family member who has had a lifelong developmental disability, who is living with family, mom and dad in Connecticut. Mom passed away. Dad was suffering from serious health issues and essentially could no longer care for this individual. And as you'll hear from Stephanie, from her brother, what was best for the family was to get Ralph, hence Ralph's Law, here to Maryland to live with his family. And despite jumping through inordinate number of hoops, hurdling over roadblocks, from December of 2024, we were not able to resolve this case. I got engaged, Delegate Kaufman, Delegate Shetty, Senator Waldstreicher, the whole District 18 team. We were not able to resolve this with DDA until literally several weeks ago, January of 2026. All fundamentally to get services for an individual who, if he had been born and raised in Maryland, there wouldn't have been an issue. And so out of that unbelievably arduous, gut-wrenching situation, we put this bill together in partnership with our amazing friends at the ARC, the Maryland Association for Community Services, the Maryland Developmental Disability Council. I shouldn't name these groups because I'll forget somebody, but with all of our friends and partners in the disability space who I know you hear from quite a bit on our incredible advocates. And we came up with a bill that we think is fairly narrow to try to address the situation of which we know we will see more of as baby boomers age and we have loved ones who are living with family members in other states. When those loved ones can't care for those individuals with disabilities anymore, and we want to do what's best for our families to be able to bring them with their other loved ones, their caregivers here in Maryland, that they shouldn't have to wait for 10 years. And so we have attempted to carve out a situation, and I'll spare you the nuts and bolts of the bill because it's not a long bill, and I know you all do your homework in many ways more than a lot of other committees. It's about, if you have been getting, essentially the criteria we set forward was if you have been getting services under a similar waiver program in another state for at least 10 years, again, we are trying to avoid, we don't want people to game the system, but if you have a lifelong disability and you've been getting services in another state, you have a family member in the state of Maryland you will be their dependent who has resided in the state for at least 2 years. Again, Stephanie has lived here for pretty much your entire adult life. And your previous caregiver is now incapacitated. This will not make you immediately eligible for services, but it will put you into the crisis resolution category, which means there will be a reasonable period of time in which you will expect to get services. This doesn't make you then immediately Medicaid eligible. It means that DDA can essentially do a sort of preview of what category you would be placed into, confirm that all of the information is correct, and then when you establish your formal residency here, nothing in this bill would change that. You cannot be eligible for Medicaid until you exit a Medicaid program in one state, establish residency here in the state, and then go through the normal Medicaid enrollment process. That's basically the bill in a nutshell. I know MDH did not submit it in advance, and I will just be very public. I got this from them at 8:45 last night. I walked them through this bill several times in January. I reached out because I saw that they hadn't filed any testimony, and I was very surprised that they hadn't shared anything publicly on the bill. So if you do not have their letter of concern, I know you will be getting it shortly. We think we have a set of amendments that we'll share with you at the appropriate time. We don't have them officially drafted. We have just sort of our plain language red line that we think address some of the concerns about potentially, are we running afoul of maybe some of the waiver requirements by creating sort of a presumptive eligibility? That's never our intent. Again, it was just to sort of carve out a new exception into the crisis resolution category, which actually is not even laid out in statute. It exists only in COMAR. But I will say, when you see this letter, they are critical of what we have proposed, but they did it themselves. And while I do not have the AG letter, one of the issues we had as we worked through this case last summer was originally DDA said to us, we can't even tell you what category Ralph would be placed in because he hasn't moved here yet. And we kept saying, well, we're not asking you to guarantee him services. We just want, based on all of the documentation that you would receive, that again, you will hear from Stephanie and the social worker that she's been working with. We just want you to tell us what would his category be? Because if you're going to place him in category 3, Stephanie may make alternative arrangements, right? If it looks like he will not get DDA services until 5 or 7 years from now, we'll figure out a way for him to stay in Connecticut. Because Stephanie works, she's got 2 kids, her husband works, like we can't indefinitely put off our careers to care for a loved one. So we will make alternative arrangements. They hemmed and hawed with us, and then they admitted that they got an AG opinion internally that said they were legally able to at least tell you what category they would be placed in. Again, that selection of the category is not a Medicaid eligibility determination. It says, if you come to Maryland and you establish residency and you meet Medicaid qualifications, this is the category that we will place you in, and this is the spot on the wait list that you will be in. But again, it is not a guarantee that you are then eligible for Medicaid. They have an AG's opinion somewhere within MDH that gave them that authority, because as you'll hear from Stephanie and you'll see in the written testimony that we submitted, it outlines the timeline of all of this. They made that determination, then they made an additional determination, but we kept fighting over ultimately what definition of crisis resolution was appropriate and how to define that category. At its fundamental core here, again, before I turn it over to the panel, this is about what we think is a really reasonable compromise for a small group of people that we will probably see more of, again, as folks age, but allows for reasonable folks, not anybody trying to jump the line or find loopholes in the system, but when you have a situation where a family member needs to move to Maryland, that they are not waiting a decade for services that they have been getting oftentimes their entire life in another state. Again, it's opportunities for us to fine-tune the language here, and I'm more than excited to work with you all and the MDH team to figure this out. And with that, thank you for indulging me. Would urge a favorable report, and again, thank you for your consideration of this.
Good afternoon. My name is Stephanie Hennis, and I'm here to support Ralph's Act. My brother Ralph is 41 years old. He has autism and an intellectual disability, which cause him to be self-abusive, verbally aggressive, and to engage in property destruction. For 20 years, Ralph attended a day program in Connecticut. It was a critical aspect of his care. It improved his quality of life and helped to limit his dangerous behaviors. In November 2023, our mother died unexpectedly, and my father began experiencing severe health problems that caused a car accident he did not remember. Ralph couldn't be cared for in Connecticut, so I submitted a DDA application with my father's detailed medical records and proof of Ralph's residency because his guardian, me, is a Maryland resident. After months of silence, DDA finally agreed to an eligibility interview, but then placed Ralph in the current request category, which would never result in any services being provided. Over the next year, I provided DDA with even more documentation. It was never enough. In the end, we were left with a choice to leave Ralph in Connecticut in my father's care or move him to Maryland without services. At one point, DDA asked whether Ralph had already been harmed in a car accident, as though imminent risk was insufficient. It felt like DDA wanted to make the process so difficult that we would just drop our pursuit of benefits. But that was just not an option for Ralph and our family. So after my father's repeated hospitalizations, an appeal, delegate intervention, retaining counsel, and moving Ralph to Maryland without any services, they ultimately put him in crisis resolution. But today he still has no day program. Ralph says that this makes him sad, and he keeps asking when he'll have a new program. The months of instability have taken a toll on him and my family. He's frequently agitated at night, and his yelling wakes my children. No one should have to go through this. Ralph's Act ensures that caregivers who are long-term Maryland residents like myself can actually obtain DDA services for their loved ones. Thank you.
Good afternoon. My name is Victoria Huffam, and I am a licensed clinical social worker. I am here in strong support of this bill, both as a professional who understands family caregiving systems and as someone who has watched this bill's namesake and his family navigate the very gaps it seeks to close. Over the past several months, I've helped Ralph's sister and her family care for him while they await the day program he desperately needs. I have seen what it looks like when a family does everything right, gathers documentation, contacts officials, files appeals, and still cannot get the state to act until something catastrophic has already occurred. As a clinician, I am trained to assess families under stress. What I have witnessed is a capable, resourceful family being worn down by a system that rewards waiting, that withholds help until something catastrophic has already happened. Ralph's elderly father was hospitalized twice for cardiac emergencies, and still the family was told the situation wasn't severe enough. I also bring a more personal perspective. I have a brother with a disability who lived in a group home in Massachusetts. For years, I thought about the future, about what would happen as our family aged, about whether I might one day soon need to bring him to Maryland to be closer to me. Watching Ralph's family go through this process made me think carefully about what that transition would look like and whether Maryland's system would be navigable for us. My brother passed away in January, and that question is no longer one I have to answer. But many Maryland families are asking it right now, quietly planning for a future where they become the primary caregiver for a sibling or a loved one with a disability. They deserve a clear and workable path. This is not just a human cost, it's a financial one. Crisis placements and emergency interventions are far more expensive than early planned services. Families like Ralph's and caregivers like me have taken leave from our jobs to fill that gap. That is real economic impact rippling out from every family left without support. This is a common sense fix. It allows Maryland residents to plan responsibly for a loved one with disabilities without the system working against them. I urge this committee to pass it. Thank you.
Good afternoon, Madam Vice Chair Collison and members of the committee. My name's Andy Culp, and I'm the Executive Director of the ARC Maryland. And we support House Bill 1015 because it creates a clear, compassionate road to stability for individuals who must relocate to Maryland after the death or incapacitation of a primary caregiver. The death or loss of a parent or primary caregiver is one of the most disruptive events in a person's life. That's obvious. And for people with significant support needs, this loss can also mean the immediate loss of housing and needed care. By ensuring an expedited determination and placement on the DDA waiting list in the crisis resolution category, the bill would ensure that continuity, predictability, and fairness during one of the most traumatic transitions a family can face. We believe this approach is similar to considerations given to military families who have a child with disabilities that has an IEP in another state. Maryland's part of the interstate compact on educational opportunities for military children, and agreements that it's designed to ease transitions for children into the state, reduce barriers to enrollment and placement for continuity of the individualized education program. So using the same concept, Ralph's Act would help to ensure that people with IDD who have relied on home and community-based services for 10 years or more in another state are not left without a pathway to support upon the need to relocate to Maryland, again, due to the loss or incapacitation of their caregiver. And I would just add that placement on the crisis resolution priority list is appropriate because one of the criteria for being placed in that category is that you have lost your primary caregiver. Another criteria is that you're homeless, which a person would likely be having just lost their primary caregiver and needing to move. So for all these reasons, we ask for a favorable report on this bill. Thank you.
Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. I'm Laura Howell. I'm the CEO of MACS, the Maryland Association of Community Services. We represent over 125 community providers of developmental disability services across Maryland. And I am here in support of House Bill 1015. As you have heard, as people with IDD, intellectual and developmental disabilities, and their primary caregivers age, it is difficult to determine the next step, and oftentimes through those challenges, not oftentimes, I misspoke, sometimes it can mean moving to another state because being with a primary caregiver that is trusted is critically important. If a parent or primary caregiver dies, the impact on a person with developmental disability is immediate and profound. Not only because of the loss, but because of the need to be able to plan for supports and services. As you've heard, House Bill 1015 creates a narrow and really compassionate pathway to address this situation for those primary caregivers who have been residents in the state of Maryland. In addition, placing eligible people in the crisis resolution category is a very reasonable approach that strikes the balance between compassion and responsible management of state resources. Maryland families who step forward during or anticipation of a crisis should not face prolonged uncertainty or unnecessary administrative barriers. For all of these reasons, we respectfully urge favorable action on House Bill 1015.
Here? Is she?
Oh, that's my chief of staff.
Right.
Just her
I know
count.
that, delegate. But just wondering if she was going to be testifying. So are there questions for this panel? We do have one virtual witness, which we'll take in a minute. Seeing none, Laura, I kind of have a question. I mean, I'm very sympathetic to the situation, so please let me put that out there. And I think what I heard you say, so I want to confirm that I understood, that, you know, because I read the letter from the Department of Health, and they have a number of concerns, but one that struck me is you know, there are a lot of people on the waiting list now in Maryland, and would this allow for people to come in, and they specifically say neighboring states, and get the services here, you know, and jump in front of folks who have been waiting. What I think I heard you say is that the crisis resolution pathway would account for that, and or account for the specific need at that moment, but wouldn't necessarily bump somebody else off the waiting list. Am I right in that, or?
Thank you, Delegate. I do think that you are correct. I don't believe that people generally leave their primary caregivers. People don't generally say, you know, until there really is a need. Parents tend to be the primary caregiver until they absolutely cannot do it anymore. So kind of this notion that people are going to flock to Maryland, particularly given the challenges that people face and that we do have a waiting list, I don't think that's going to happen. We've gotten these calls from time to time of, where it really is a crisis for the person living in another state and that sibling. Siblings are the next set of primary caregivers. And if they've been Maryland residents and the person with the disability has been receiving those services for at least 10 years, that is a narrow definition, and I think it is the right thing to do because that primary caregiver is a Maryland resident. It's not like an entire family is picking up and moving to Maryland and saying, oh, I want to come to Maryland for services. This is a very specific set of criteria. I hope that answers it.
Thank you. That helps. Thanks.
I was going to say, Delegate, just 2 points that I wanted to add. So we don't have an official definition of incapacitation. It's in the bill as sort of part of the criteria, but there are a number of definitions. The one that we pulled that was sort of, I think, closest to what we were trying to get, it's in COMAR in Chapter 24 on medical assistance eligibility, and it lays out essentially incapacitation, mental or physical defect, and illness or impairment, which eliminates the parent's ability to support or care for the child. So we tried to make it as clear as possible that you couldn't really game this. It was the drafter that we worked with suggested sort of the 2 years, a reasonable limit. I think we could say, they could be a resident for longer. Obviously, in Stephanie's case, she's been a resident for 20 plus years. The other thing I'll just point you to, the fiscal note at the very end, the fiscal note team at DLS did say they felt like because of the criteria and the limiting factors, they believed it was a significantly small number of folks who might qualify for this. So I think we tried to strike that right balance.
Just before we go to the next panel, Delegate, you said you were working with the department on this legislation previously, but then this position was a surprise to you. Can you just talk about the work that you were doing in advance of the hearing?
So we had been talking with them. I mean, again, it wasn't honestly until the second week of January, the third week of January, that we officially got word from DDA that Ralph was going to be moved into the crisis resolution category. And at that point, the bill was well into drafting. We didn't have an official draft back yet. We had an outline, and then the bill was dropped. I think we got this bill back literally the day before the drop deadline, so it has been in for 2 weeks, and we walked through it. We without the language, we did walk through what was in the bill. I was just significantly surprised that I hadn't heard anything from them, and frankly, I'll be honest, the way that we had been treated, I was expecting them to come to us with a, hey, we know this bill is here, we know you've told us about it, here's where we are. I'm a little disappointed that we got the letter, literally at 8:45 last night, with not a whole lot of explanation. So again, the amazing team that we're working with of advocates, we have some amendment ideas that I think touch on some of them on their concerns. It's not to say that those concerns are not legitimate. I will say there's a chunk of that letter in particular about the sort of predetermination before they become Medicaid eligible. That in particular, they told us in the fall of 2025 that they were unsure whether they were legally allowed to do that. They got an AG's opinion internally that said they were able to do the placement, the crisis categorization determination. And so my comment to them was, I want to make sure that you don't run into a situation where in another administration, an AG interprets something differently. We want to codify that protection. So part of the reason the bill says you can do the crisis placement determination in advance, again, that's not Medicaid eligibility, is because of what they told us they got from their AG. So I was particularly frustrated to see that somehow called out in this letter as running afoul of, nobody's trying to ruin the state's Medicaid waiver by any stretch. But again, I think we have some really good ideas here working and excited to work with MDH going forward to make sure that we're in a good place with this.
Thank you very much. And I will say, in defense of MDH, we have been getting a lot of guidance, and there have been a lot of changes with the Medicaid waiver programs, and I believe that we have to start the renegotiation of the waivers in this cycle. So I'm going to strongly encourage, have conversations with the department, and let's figure out how to thread that needle and make sure that we're staying within the latest guidance from CMS, because sometimes, as you know, we do get some conflicting information. So, and I think we have one more witness, we have a virtual witness on a favorable panel, is that correct? This is your whole panel, correct?
This is our panel, yeah.
All right, so this concludes this panel. We do have a favorable witness who is virtual, Amanda Mummert? No. Oh, okay, so Amanda is not in the waiting room.